In this episode, we are going to discuss the topic of trademark registration for personal names. From a trademark perspective, nothing serves as a stronger identifier than an individual's personal name. But does this make personal names, first names, surnames, or a combination of the two, appropriate for trademark registration? Trademark law has always treated personal names differently. In the past, a person was free to use his or her name as a trademark and was not obligated to defend against a claim of trademark infringement by another person with the same name. More recently, however, trademark law has evolved to allow personal names to be protected as trademarks, but only if they have acquired a secondary meaning. Let's pause for a second to discuss secondary meaning. Secondary meaning is the same thing as acquired distinctiveness. Some confusion is created by these two labels, which mean exactly the same thing. The more descriptive and the less inherently distinctive the trademark, the greater must be the quantity and quality of evidence of secondary meaning to prove the level of distinctiveness necessary to achieve trademark registration. In order to prove that a personal name is a valid trademark, its owner must provide that consumers have come to understand the personal name to identify a particular business product and/or service. For example, a consumer seeing the Hurley brand for the first time might have thought that someone with the surname Hurley was associated with the clothing line. And they would be right. Bob Hurley was one of the founders of this clothing company. Today, Hurley has gained an extraordinary amount of acquired distinctiveness and is plainly a registerable and protectable trademark. Consumers have come to see the Hurley name as signifying a business that produces clothing and surfwear, rather than a person connected to the business. When selecting a trademark to identify your particular goods and/or services, you need something that is capable of distinguishing your goods and/or services from those of others. It may seem intuitive that a personal name would serve that purpose perfectly. In fact, celebrities, including Vera Wang, Taylor Swift, Michael Jordan, Kelly Slater, and Tiger Woods, to name a few, have secured a trademark for their names. However, there are challenges to effectively protecting one's personal name as a trademark. Let's talk about 4 bars to federal trademark registration that may apply to personal names. First, an applicant may not register a mark that is primarily merely a surname unless it has acquired distinctiveness or secondary meaning. Second, when an applied-for mark comprises the name of a living person, that living person must explicitly consent to registration, or the USPTO will issue an office action refusing to register the surname. Third, an applicant may not register a trademark that falsely suggests connection with a person that is living or dead. Fourth, an applicant may not register a trademark that disparages a person that is living or dead. To be registered as a trademark, a personal name must be used as a trademark. In other words, the personal name must be used as a source identifier to distinguish the goods and/or services associated with the personal name. To be registered as a trademark, a personal name must be used as a trademark. In other words, the personal name must be used as a source identifier to distinguish the goods and/or services associated with the personal name. To serve as a trademark or achieve federal trademark registration, the personal name, even a well-known celebrity name, must be used in connection with goods and/or services. In addition to the use requirement, a showing of secondary meaning is also required to protect a personal name as a trademark. There are at least 3 types of evidence of secondary meaning that may be relied upon when applying for a federal trademark registration. The first is direct or circumstantial evidence tending to prove that the relevant buyer class associates the trademark with the applicant. The second is proof of 5 years of use. The third is evidence of ownership of prior registration on the same trademark for closely related goods and/or services. This means that a personal name can be protected as a trademark only if the owner can prove that through use it has acquired distinctiveness or secondary meaning in the marketplace. Note that secondary meaning is a requirement of registration only for trademarks that are primarily merely a surname. On the flip side, if consumers would not see the trademark as a personal name, then proof of secondary meaning is not required. Since we are discussing the topic of trademark registration for personal names, it is important to note that the Trademark Manual of Examining Procedure, TMEP, states that exclusive rights in a surname by itself cannot be established without evidence of long and exclusive use that changes the surname significance from that of a surname to that of a trademark for particular goods or services. Here's another important point. Applicants, and this could be you, do not have the burden of proof in a surname determination. In other words, if an application is rejected on the basis of the mark being primarily merely a surname, it is the USPTO examining attorney who must present evidence that the applied for trademark at issue is primarily merely a surname. If the USPTO examining attorney submits evidence that the applied for trademark is primarily merely a surname, the burden then shifts to the applicant to rebut that evidence. If there is any doubt about whether the mark is primarily merely a surname, the Trademark Trial and Appeal Board, TTAB, will resolve that doubt in favor of the applicant. While establishing secondary meaning can often be a challenge, a personal name can become a strong mark, such that consumers recognize the name as identifying certain goods and/or services from a particular brand or source. For example, the marks Tiger Woods, Ford, and McDonald's are all personal names that serve as strong and effective trademarks. Let's conclude with 5 questions to ask when deciding whether to use your personal name as a trademark set forth by the Trademark Trial and Appeal Board. Number 1, is the surname rare? Number 2, is the term a surname of anyone connected with the applicant? Number 3, does the term have any recognized meaning other than a surname? Number 4, does the name have the structure and pronunciation of a surname? And number 5, is the stylization and lettering of the surname distinctive enough to create a separate commercial impression? Unless a trademark applicant's name satisfies each of these 5 factors, he or she is likely looking at an uphill battle for registering and protecting his or her name as a new trademark. Therefore, unless a trademark applicant is absolutely set on using his or her personal name in a trademark fashion, exploring more creative options for a trademark may be a better, less challenging, and less costly path to achieve trademark registration. If you have any questions about trademark registration for personal names, please call us or email us. We are here to help. Thank you for watching.